economic growth in Indonesia. Thank you all for finding the time and visiting this webinar. This webinar is hosted by the Law Faculty of Universitas 11 Maret. My name is Tika Andarasni as Master of Ceremony in this webinar. This is a very golden opportunity for us to have Prof. Madya from University Utara Malaysia, Dr. Edmond Makarim from Universitas Indonesia, Mr. Jeko Berhushen, PhD from University of Limpopo, Prof. Pujiono from Faculty of Law, Universitas 11 Maret, Prof. Kusrianti from Universitas Erlangga, and Professor Haitian Lu from the Hong Kong Polytechnic University as the speaker in this international webinar. Before we start the international webinar, let us listen to the Indonesia Raya anthem. Polytechnic University as the speaker in this international webinar. Before we start the international webinar, let us listen to the Indonesia Raya anthem. Polytechnic University as the speaker in this international webinar. Before we start the international webinar, let us listen to the Indonesia Raya anthem. Polytechnic University as the speaker in this international webinar. Before we start the international webinar, let us The first occasion is opening remarks by Dean of Faculty of Law, Universitas 11 Maret. Profesor Gusti Ayu, the time is yours.
Oke, terima kasih Mbak Tika. Bismillahirrahmanirrahim. The Honorable Rektor Universitas 11 Maret, Profesor Dr. Jamal Wiwoho SHM. The Honorable Vice Rector Universitas 11 Maret, Profesor Ahmad Yunus. Assalamualaikum, Prof. Yunus.
Waalaikumsalam. Good morning, Prof. Ayu.
The Honorable All Speaker, Profesor Adi Sulistiono. Chairman of the Senat Universitas 11 Maret, Profesor Maida Dr. Zuriati binti Muhammad Yusuf, Associate Professor, School of Law, Universitas Utara Malaysia Kolgis, Dr. Edmond Makarim, Eskom SH LLM, Dean Faculty of Law, Universitas Indonesia, Profesor Jeko Berghuizen, PhD, Head of Department Criminology and Criminal Justice, University of Limpopo, Profesor Dr. Pujiono, SHMH, Vice Dean Faculty of Law, Universitas 11 Maret, Profesor Kusrianti, SH LLM, PhD, Professor of Law, Faculty of Law, Universitas Airlangga, and the last but not least, Professor Haitian Lu from the Hong Kong Polytechnic University. the Honorable all participants. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Selamat pagi. Good morning, ladies and gentlemen. Thank you to each and every one of you for being here today in International Law and Economic webinar with topic Small and Medium Enterprises Development Strategy in the Post-Pandemic COVID-19 Era to Increase Economic Growth. Ladies and gentlemen, the objective of this international webinar as a forum for exchanging ideas for various parties with an interest in dealing with the impact of pandemic on the economic sector comprehensively. And the second, providing public understanding and insight about the impact of a pandemic to micro, small, and medium enterprises. And the second, encouraging students at the bachelor, master, and doctoral levels to produce scientific papers within the scope of the theme of the role of law in the economics of sustainability. And the last, the fourth, building cooperation networks with various national and international parties. I would like to express my appreciation to Bapak Rektor Prof. Jamal and Vice Rector Bapak Profesor Ahmad Yunus, all speakers and all participants who help us make this webinar come true. I would like to say once more on behalf of Faculty of Law, Universitas 11 Maret, and organizers, welcome. It's great to see so many of you here. That's all. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh. Terima kasih Mbak Tika, monggo.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Professor Ayu. Now please welcome Professor Ahmad Yunus to give keynote speech in this international webinar. Professor Ahmad Yunus, the time is yours.
Ya, thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semuanya. Om Swastiastu, Namo Buddhaya, salam kebajikan. Good morning, ladies and gentlemen. The Honorable the Dean of Faculty of Law, Professor Igusti Ayu Ketut Rahmi Handayani, thank you for your attendance in this international seminar. Also the Honorable Vice Dean, Professor Pujiono, and our speaker, Professor Edmond Makarim, the Dean, Faculty of Law, Universitas Indonesia. Thank you for your time and participation. Also, the Honorable Dr. Zuryati from University Utara Malaysia, Professor Jeko from Limpopo University, and Professor Kusrianti from Universitas Airlangga, and also Professor Hu Tianlu from Hong Kong University. With respect to all the participants, even though it has passed, the COVID-19 pandemic still significantly influence various aspects of human life in plenty countries, including Indonesia. Many workers have to lose their job, and even many micro, small, and medium enterprise no longer have any fund to run their business. In contrast, the role of micro, small, and medium enterprise in economic sector of Indonesia is prominent and significant. The escalation or degradation in economic growth in Indonesia must be influenced by the involvement of micro, small, medium, and enterprise. As a state in Constitution, our Constitution, Undang-Undang Dasar 1945, Artikel 33, Paragraph 4, micro, small, and medium enterprise are the part of Indonesian national economy and have the potential to improve people welfare and economic growth. Based on the Ministry of Cooperative and Small and Medium Enterprise information, in March 2021, number of MSME actor in Indonesia raised until 64.2 million, with contribution to GDP 61% or 8,000 trillion rupiah. This is enough to explain how significant the MSME sector for development of Indonesian economy. The development of MSME is very strategic because its great potential in driving the community economic activity and as source of income for the majority of community in Indonesia. However, based on the survey result in Indonesia Business Development Services Association, the total from 6,000 MSME surveyed, the result is 26% of them experience a degradation in business activity is more than 60% during the pandemic. Meanwhile, the MSME cannot do business until 36% of total respondents. Among the MSME affected by this pandemic, many parties will face the difficulties of getting up and recovering from their condition because they are carried away by the tide of the pandemic. Even though this pandemic is slowly starting to show the way out, the reality is that the plenteous of MSME, many don't know about to step up of the tunnel to get back on the road after COVID-19. Therefore, this is the reason why we are gathered today to discuss about this forum, expert from the within and outside of the country to gain insight, enlightenment, and analysis, and give the solution to solve the problem. We also provide this activity where we collect the best critical idea to contribution from all our participants, from undergraduate and graduate students, through their best written work, especially in law. This activity also expected to be a forum explore our knowledge and analytical ability to solve the problem. As we know that now the UNIED, University Network for Indonesia Export Development, with partner with the Lembaga Pengembangan Ekspor Indonesia, Indonesian Export Development Council, to get or to build the development of MSME to gain or to improve the export, and their program is called Desa Devisa. And the UNS is one of the member of UNIED, University Network for Indonesian Export Development. And with from the committee with the say Bismillahirrahmanirrahim, the webinar with topic small and medium enterprise development strategy in the post-pandemic COVID-19 era to increase economic growth in Indonesia is officially open. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Professor. Now we enter the main occasion of international webinar, which will be handled by Ms. Umi Khairahpati as moderator. Ms. Umi Khairahpati reached her master degree from Universitas Gadjah Mada, Yogyakarta. Now she is a lecturer in Faculty of Law, Universitas 11 Maret. Please welcome Ms. Umi Khairahpati. The screen is yours.
Thank you, Putika. Good morning, everybody. My name is Umi Khairahpati, and I will be the moderator for this occasion. Thank you to all our presenters today, and thank you for attending this seminar. Ladies and gentlemen, we all know that we are now in the post-pandemic era, and we want to know how would reshaping the regulation after pandemic, especially in the field of small and medium enterprise field development strategy. So in this occasion, Faculty of Law present the international webinar with the topic of small and medium enterprise development strategy in the post-pandemic COVID-19 era to increase economic growth in Indonesia. In today, we have some presenters or speakers coming from the best university in Indonesia and overseas. And before we start, I have a few notes for both speakers and audience. First, each presenter will have a total of 15 to 30 minutes for their presentations. And before they start the presentation, I will read their brief introduction respectively. And the second, the questions and answer session will be open after all presentations have done. And the third, if you have any question of the presenters in the question and answer session, please raise your virtual hand on the corner of the screen and turn on your microphone when I call on you to ask a question. You can also use the chat feature, then I will read your questions out loud. Now let's move to the first speaker, who will be speaking to us about Malaysia's economic condition during COVID-19 pandemic and post-COVID-19 pandemic, and explain the skills and law regulation needed as a form of innovation in the post-pandemic world. Before she starts, I will introduce the professor briefly, Prof. Zuryati. Let me share her CVs first. As you can see on your screen, Professor Zuryati Muhammad Yusuf is an associate professor. She graduated from Victoria University of Wellington, New Zealand, with the field of privacy law in 2014, and graduated from Master in International Islamic University in Malaysia for comparative law field, and Bachelor in International Islamic University in Malaysia. She was a member of Malaysian Bar and awarded from some recognitions and awards, like in 2018, a Master Certificate in Women Leadership in the national level, and Anugerah Perkhidmatan Cemerlang in the or university level. She also responsible for some courses, especially for business field, and she also conducted some research and published some publications or paper in both national and international journal. And she also active become a supervisor, both internal and external examiners. Okay. Without any further ado, now let's please welcome Professor Suryati Mohammed Yusuf. 30 minutes is yours. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and very good morning. Can all of you hear me?
Yes, very good.
First of all, I would like to apologize for the actually I'm not feeling very well today this morning, but due to this commitment, I have already had a very good relationship with Universitas 11 Maret. And this is the second time I have been invited as the speaker. So because of that, I don't want to lose this opportunity to speak to all of you, to share the Malaysian experience on this small and medium enterprise after the post-pandemic. So I hope all of you can bear with my serak basah voice. Okay, so let me share my screen. Okay, as I said just now, this is the second time I've been invited for this international law webinar organized by Faculty of Law, Universitas 11 Maret. I'm very honored for this opportunity, and I would like to thank this Director, Prof. Jamal, the Vice Rector, Prof. Yunus, and especially my appreciation to the Dean of Faculty of Law, Universitas 11 Maret, Professor Dr. Gusti Ayu, and also my colleagues, Dr. Dian, and also respected speakers for today's webinar. Thank you very much. For the opportunity given. Okay, so without further ado, I would like to continue with the some interesting sharing with all the participants today. So I have decided to talk about the legal impact of COVID-19 on small and medium enterprise, SMEs, towards post-COVID-19 economic recovery in Malaysia. So I hope the sharing today will at least give us some input on how to improve, especially the economic condition in our countries, and we need to, the life must go on because the pandemic nowadays has already getting its way out of the world. Okay, so inshallah everybody will have our normal life previously, inshallah. All right, so as an introduction, okay, actually without introduction, all of us aware that the COVID-19 pandemic is an unforeseen global phenomenon which has thrown the economy into chaos and effectively put commerce at a standstill. Okay, we still remember the experience of 2 years back on how everybody stay at home. Okay, every business has been shut down because of this pandemic. It has affected most businesses, including the small, medium enterprises, SME and micro SMEs, which make a significant 98.5% of Malaysian businesses. in Malaysia, this SME business is the most popular business that contribute to the economic growth of Malaysia. And as said by Professor Yunus just now, the same situation is in Indonesia, whereby the biggest chunk of economic contribution come from SME business. SME are the most affected sector due to their role as the backbone of the Malaysian economy. And the world has experienced this most unexpected phenomena where public health, social well-being, life, education, as well as economy are disrupted, each country equally. So without exception, each country in the world has experienced this bad impact of pandemic COVID-19. Okay, before I move further, let us together have a look at these categories of SME. Okay, I'm sure all of you have the idea of these categories, but for the purpose of recall the information, so let us share these categories of SME business, okay, whereby it consists of micro, small, and medium. Okay, for micro SME business, the sales less than in Malaysia, ringgit Malaysia 300,000, or staff have the staff less than 5. That is for manufacturing. And for services sector, the sale less than 300K, or staff less than 5. Okay, for small business, the sales between 300,000K and 15 million, or staff between 5 to 75. And for services and other sectors, the sales are between 300K and 3 million, and the number of staff between 5 to 30. Okay, and for medium business of SME, okay, the sales are more than 15 million but not exceeding 50 million, of staff from 75 but not exceeding 200. And for services and other sectors than manufacturing, okay, the sales more than 3 million but not exceeding 20 million, or staff of from 30 but not exceeding 75 persons. Okay, so these are the category or the yardstick of SMEs, whether it can be considered as micro, small, or medium. Okay. So we cannot deny the importance of SME, okay, whereby it immensely contributes. Immensely contributes to the socio-economic growth and development. Okay, it has a significant impact on the relationship between entrepreneurial orientation and SME's performance. Okay, SME also contribute to gross domestic product, GDP, as I said just now. Okay, it's contribute almost 98.5% of the GDP for Malaysia. And it's also create, okay, the employment opportunities. Okay, we know everywhere in the world, okay, the involvement in SME business has created a lot of employment opportunities to the nation, to the citizens of the country. And SME also have been performing a primary role on the overall economy. Okay, the growth of local products depends on the SME business. Okay, SME business also open a new market development and also growth of export earnings. Okay, so when we understand that the contribution, okay, the most important contribution of the world of the state or the country economy depends on SME business. So these are the importance that we can see from this business. Okay, so having said that, okay, SMEs has its own challenges. Okay, and among the challenges is that because of the unstable policy, we know that because of the pandemic COVID-19, there's a lot of changes in the regulations, in the policy, okay, to keep with the or to correspond with the status of COVID-19 daily. So the government has to change the policy, has to change the regulations, and this unstable policy has become among the challenges of SME business to grow or to develop during the pandemic situation. Okay, other than that, okay, we know that SME stand for small medium enterprise. So we can understand that the inadequacy of finance, okay, is one of the challenges to SME, because SME is normally business starts from the rural area or local area, and it start from a very low budget, low cost. Okay, so that one of the challenges of SME is that they do not have adequate finance, okay, to support the business or to grow the business. Apart from that, okay, the SMEs also has the problem in lacking the adequate infrastructure. Okay, lack of adequate infrastructure. Another challenges of SME is the inadequate transportation. Okay, because of the business starts from a rural area or a very remote area. Okay, so they will experience the inadequacy in transportation. Okay, in order to promote or to grow their business. Okay, apart from that, okay, the SMEs also is considered to have the challenge in terms of lack of patience and curiosity for investment. Okay, perhaps because the players of these SMEs, okay, are people come from maybe in terms of education background, it is not as good as compared to these big businesses. So they have a lack of patience, okay, in terms of investment, okay, in order to grow their business bigger and bigger. Okay, and apart from that, the social political ambition of entrepreneurs also become one of the challenges for SMEs business. Okay, having said that and having discussed about that, we can see the impact of COVID-19 on SMEs, okay, whereby this unprecedented outbreak of COVID-19 has affected all facets of life, such as education, whereby all students have their schools at home, okay, every day facing the screen, okay, in order to continue their education. Okay, those are the things that happen that we never expected before. Okay, the COVID-19 also affected the social activities, whereby in Malaysia we have the MCO, movement control order, where every citizen need to stay at home. Okay, only can go out for the necessities. Okay, and of course there's a lot of social activities that cannot be continued as a result of the COVID-19. Political governance and economic dealings, without exception, these are the aspects that has been badly affected by the COVID-19. And most business transactions since the emergence of the deadly virus recorded low sales, and most SMEs are no exceptions. Okay, these are the reason, okay, why a lot of countries have facing the economics problem due to the pandemic COVID-19, and changes in business strategies, operations, and business conduct, as well as pressure to search for new sources and opportunities for development, are considered as critical survival strategies for most SMEs. So I'm sure all countries in the world has experienced this situation during the last 2 years. Okay, we cannot deny the fact that COVID-19 has created negative impact on the overall operations of SMEs in Malaysia and requires urgent measures to address the catastrophe. In terms of legal impact, it affects the economic relationships with the government, such as statutory and tax regulation, financial sectors, such as insolvency regulation, global demands, such as contract with suppliers, immigration rules or custom requirements, and labors or household on the employment, EPF or price control regulations. So having seen these are the impact that we can say from the legal perspective. Okay, what the COVID-19 has done to the economy, and it entails with it the legal impact on it. In response to that, okay, the government has been making tremendous effort in getting support for strengthening production at the manufacturing industry as a way of post-COVID-19 economic recovery strategy. So after this, I will talk about the efforts taken by the government, okay, in order to recover the economics, in order to help the SME business, okay, to boost again their economy. Okay, among the strategies, okay, the Malaysian government has responded to this coronavirus threat by introducing Prihatin, okay, or the Prihatin Rakyat Stimulus Package, where the purpose of which was to ease financial burdens of the people and businesses coping with the pandemic. The Malaysian government has introduced this grant, okay, to help the financial burdens of the small and medium businesses. Okay, and Malaysian also introduced the wage subsidy programs, apart from Prihatin package and managed by the Social Security Organization. Okay, under this subsidy program, the employer will given the subsidy, the financial helps in order to pay wages to the employees. The government also give the enhancement to financing facilities to assist affected SMEs, safeguard jobs, and support growth. In doing so, okay, all bank industries in Malaysia has adequately follow this enhancement to financing facilities in order to help businesses in Malaysia. We also have programs to support the B40 segment in generating sustainable income and achieve financial resilience. Okay, the B40s are the most biggest population in Malaysia, and they are also the most biggest employers of SME. So in supporting their economic position, okay, the government has already have this program. We call it inthe card, okay, in order to help the B40 to generate sustainable income. And the government also introduced relief measures for affected policyholders and takaful participants. Okay, so the banking industries, the takaful players, the policyholders, okay, working together hand in hand, okay, in order to come forward with the strategies in order to recover, for economic recovery in Malaysia. Okay, Bank Malaysia in its report concurred that SME are a critical component of the Malaysian economy, contributing more than a third on gross domestic product and providing job opportunities for more than 4 million workers in Malaysia. So with this information, we are crystal clear with the information that SME are the most important component of Malaysian economy, and it helps a lot in providing job opportunities to Malaysians. Okay, and banking institutions are the main source of financing for SMEs, providing more than 90% of total financing. Okay, so the provision of SME financing is also complemented by the development financial institutions, Bank Negara Malaysia's Fund for SMEs, and government funds. So in this situation, okay, all parties working together hand in hand in order to help the SMEs in Malaysia. Okay, and Malaysia also introduced the National Economic Recovery Plan, or called PENJANA, which provides additional support for SMEs. There are 40 short-term plan initiatives and 24 initiatives worth 14.5 billion prepared for the SMEs. So SMEs has never been left alone, okay, in facing this catastrophe. Okay, the governments work hand in hand with all the necessary parties, okay, in order to help the SMEs. Okay, so overall, these are the strategies or the steps taken by the Malaysian government in order to help the SMEs. Okay, first of all, we realize that we need to improve the institutional support system. We need to facilitate the accessibility to financing. We need to upgrade the technological skills to enhance market access, to promote the greater usage of ICT, and to increase awareness of product branding and protection of intellectual property rights. So these are the overall initiative and overall recovery strategies that has been put forward by the Malaysian government in order to help the SMEs. Okay, and in addition to that, in order to enable the SME in rural industries to penetrate world markets, efforts to enhance their competitiveness will be intensified. The concept of one district, one industry will be strengthened. Okay. Initially, Malaysia has introduced the concept of one district, one industry, and this concept has been strengthened to cover a wider area of participation. Efforts will be geared towards enhancing the use of technology. Okay, we cannot deny the importance of technology during the pandemic and also post-pandemic. Okay, especially in rural industry production processes, acquiring quality accreditation and upgrading market promotion by establishing link with corporate and international clients. So these are the big picture of recovery strategies in Malaysia that we have done in order to help to support the SMEs business in Malaysia. So in order to ensure micro entrepreneurs to manage their business in a crisis situation, specifically in a less developed area, it is crucial to provide assistance and support facilities that are more relevant to them, especially in terms of knowledge and skills on crisis management methods. And we also supply to them the business knowledge like online marketing techniques, product delivery procedures, new product development, costing and pricing strategy during crisis, and customer database management, which could serve as a basis of crisis management plan for micro enterprises. So these are the knowledge, these are the ilmu that we need to enhance within the SMEs players, okay, so that they can continue with their business strategies during the post-pandemic. And as I said just now, when I mentioned about ICT, okay, it is the digitalization and automation in the business operation is needed. Okay, most of the businesses has gone one step further, one step ahead in employing all this kind of digitalization. They digitize their business. Okay, they have their digital transformation process. Okay, in order to develop their business. Okay, it involves the usage of technology within the business to drive and improve efficiency and competitiveness. The pandemic COVID-19 crisis has prompted SME to adopt technology as the solution to remain sustainable, to be competitive, reaching out and be engaged globally by making strategic decisions. Apart from digitalization and technology adoption, businesses must be open to diversifying their revenue stream, and this means they must explore other industries so that they will not be overly dependent on one revenue source. Those are the strategies, recovery strategies, and we cannot deny the importance of legal measures, okay, in promoting these post-pandemic strategies. Okay, in Malaysia, the government has introduced the COVID-19 Act. Okay, the full name is Temporary Measures for Reducing the Impact of Coronavirus Disease 2019. And under this act, okay, this is actually bolster the prevention and control of infectious disease act, as there will be numerous legal ramifications after the lifting of MCO. In order to reduce the impact of COVID-19 through modification of relevant statutes, such as Limitation Act 1953, Hire Purchase Act 1967, Consumer Protection Act 1999, Commercial Vehicles Licensing Board Act 1987, Distress Act 1951, Employment Act 1955, and many others. These acts have come into hand in hand with the COVID-19 Act, okay, in order to reduce the impact of COVID-19 on businesses in Malaysia. And we can see the seriousness of Malaysian government in promoting the adaptation of e-commerce transactions among SMEs, in particularly during this economic crisis periods. And from the slides just now, we can see the importance of digitalization of SME business, okay, and action taken by the government in order to assist SMEs towards enhancing their products and providing better services. This effort has its own challenges in terms of bridging the digital divide between Malaysians, between urban and among Malaysians, between urban and rural areas, as well as between age groups ranging from young to old. However, the blessings of virus is finally realized by all Malaysians, whereby it made us aware of the importance of accelerating this digitization effort in not solely for economic recovery, but equally important for other aspects of life. Similarly, legal response needs to be in place in creating and normalizing the e-commerce system. Thus, the government has taken a firm approach and action by creating special laws related to e-commerce based on the appropriateness of changes that occur from time to time. The enactment of a reform of laws related to e-commerce enables the rights of customers and operators to be protected in the event of an unpredictable situation. So with that, I end my presentation and I welcome all the questions at the end of the session. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Professor Suryati, for your insight sharing. As I noticed, I will thank you. Okay, I will conclude or make some how to say notice with your presentations. As you say that SME also the backbone of the Malaysia economy, and Malaysia has taken several steps for recovery, like stimulus packaging and wages subsidiary program, and some program like financing and how to say assist and support some facilities for SME. Yeah, thank you, Professor, for your insight. And we are moving to the next speaker, Prof. Jeko. Yes. The next speaker is Prof. Jeko. Hello, Prof. Jeko.
Good morning, everyone.
Good morning, Prof. Nice to meet you again in this forum.
Thank you for having me. Should I begin?
Firstly, I want to introduce you briefly.
Okay, that's fine.
Let me share your CV first. Okay. Wait a minute. Yeah. Hopefully you can see the CV on your screen. Professor Dr. Bergzen Jeko, or Jeko Bergzen, he graduated from Tokiwa University, Japan in 2008, and also graduated in many bachelor in the University of Pretoria in 2002, University of Port Elizabeth, Nelson Mandela University 2001, and University of Pretoria again in 2000. He took his master in University of Pretoria in 2004, psychology. So you have many kinds of major, Prof. And then many qualification, teaching and learning courses, also become a supervisor for internal and external examiners. You have many courses and supervise doctor candidates. PhD and master. Also doing some research and public services funded by national and international awarded. Okay, that's a brief of introduction of Professor Jeko. Please welcome, Prof. Time is yours, but the committees have told me that your time just 15 minutes. I'm sorry.
Okay, I will. That's fine. I'll try and be fast.
Okay.
Let me get from the beginning.
Yeah.
Okay.
Please.
So, thank you very much. So, I'm going to talk about the ideal type of law or legal paradigm we should look at in the post-pandemic era. But to do that, we need to look at what is justice, what is social justice, what is victim justice, and what is the future direction of justice. Now, what is justice? That's a concept as old as society. Our first legal code that we know of is the Code of Hammurabi. The Code of Hammurabi formed the legal basis or the basis for all other religious codes. So the most Abrahamic religions used the Code of Hammurabi. The Zoroastrians used the Code of Hammurabi. So the code, and then the Code of Hammurabi also got integrated in all societies that grew out of the Mesopotamian area and the interaction between the Mesopotamian people and the rest of what we call the world that time. Now, then we had the Romans, and they basically conquered what was the whole of Europe. And that conquering, with their conquering, they brought with them the Roman law system, right? And as the Roman law system got integrated into European societies, now in the age of exploration and colonization, the Dutch took that Roman law system, which they made their own, called the Roman Dutch law, and they took it into other countries. For example, South Africa, we follow Roman Dutch law. It's a basis of our law. Indonesia, you also have Roman Dutch law as a basis because of the Dutch colonized South Africa and the Dutch colonized Indonesia. So what is justice? Now, the definition, if you look at it, is an action in accordance with the requirements of some law. Whether the rules are grounded in human consensus or societal norms, they are supposed to ensure that all members, this is important, that all members of society receive fair treatment. Now, it should instill a sense of stability, well-being, and satisfaction among society members. The principles of justice and fairness should be the ground of it. Now, what is the principles of justice and fairness, right? So you have distributive, procedural, retributive, and the newest form, well, it's not really that new, but it's now being codified into laws, is restorative. Now, these types of justice have important implications for socioeconomic, political, civil, and criminal justice, both at national and international level. But when we talk about justice, we have to talk about fairness. Why? Because people like, and our ministers and our judges like to use the terms interchangeably. It's fair and it's just, or it's justice. That means it's there's fairness. Now, justice refers to laws, but the question is, are all laws fair? And we know throughout history that the construction of laws is not always fair. Laws are based on a social construct, right? And it can be unfair. Apartheid in South Africa was legal. The laws were made to make it illegal for people of color to have the same rights as white people. And then if we look at Nazi Germany, the laws against Jewish people, against the Roma, against the Gypsies, those laws were legal. It was codified and judges enforced these unfair laws, referring to it as justice. So we have to remember that justice actually is socially constructed rules of behavior enforced by a social contract between state and society. The main aim of all justice is to ensure that it's fairness for all. But does it really happen? If we look at what happened during the pandemic and how countries reacted, and how they brought in extra legal actions, how they banned certain things. For example, in South Africa, the government banned cigarettes or tobacco products. And eventually now the constitutional or the Supreme Court ruled that what the government did in terms of the banning of cigarettes and tobacco project was actually unconstitutional. So governments overreact sometimes, and they codify things that is not fair and is not based on the social contract between state and the society. So we have to look at a social justice system. Now, social justice means equal rights and equitable opportunities for all. So this is equal rights, equal opportunity, and equal treatment. This is actually the core of all supposed to be justice system, that everyone is equal in front of the law, everyone has the same opportunities, everyone is treated the same. Now, it's an iterated principle of social justice. So it's equity, you have access to justice, you may participate in justice, and everyone has rights that are protected. But now, if you look at the world and how the world is changing, are we really achieving the social justice goals? Are we achieving justice as it relates to crime and crime victims? Now, if you look at something called victim justice, you have to look at a guy called Beccaria. Now, all the legal guys sitting in this will remember Beccaria is sort of the guy that gave us the modern criminal justice system. Now, he wrote a book on crimes and punishment. And if you understand why he wrote that book, what was happening in Europe at the time is that people were tortured. You could be killed based on false accusations. Modern justice, he's the one that developed the idea that you have to face your accuser in an open court. You're innocent until proven guilty beyond reasonable doubt. In Europe during his time, that was you were guilty and you had to prove your innocence, and which we all know is highly impossible to do. Now, to understand victims' justice, we need to find out what is a victim and who is a victim. Now, the victimization, and it's an act. First, let's define a victim or a victimization. It's an act or omission that causes harm. It is an invasion into the self, and the harms caused by victimization is psychological, financial, physical, emotional, social, especially in our post-social media era, and then environmental. Now, for those that attended some of my previous classes, you'll know this is basically the concept of the third branch of victimology. And those who are interested that don't know what victimology is, the organizers will share my email with you and you can explain nicely again. So we need a justice system post-pandemic that is based in international humanitarian law, that's based on the UN Declaration on the Rights for Victims of Crime and Abuse of Power, a criminal law that is changed from the idea of criminal law to victims' justice. We should move away from calling it a criminal law to victim justice. And one of the building blocks of such a justice system should be based on the ideas of restorative justice. Now, what is restorative justice? Basically, the word says it all. It restores the imbalance between offender, victim, and society. So what needs to be restored? When the offense happens, it not only hurts the victim or harms the victim, it's also due to harms done to the victimizer from society's side. And society is harmed. So you have these three components that needs to be restored: society's harm, the offender's harm, and the victim's harm. In my opinion, that's the only true justice that we will find, because the victims can ask questions. Society can then see how they can help an offender from not offending again, and the offender can see the harm his or her action has caused, not only the victim, but society as well. And the restoration then would be psychological, would be financial, physical, emotional, social, and environmental. Now, can we speak of justice and human rights if we don't deal with the rights of victims? Because human rights are at the core of it, victim rights. Every human right we have is based on someone's victimization, that we said we can't allow this anymore. The rights for women are basically because women were victimized throughout the centuries. The rights to join unions was because union membership was deemed illegal throughout the years, and people got victimized and killed because of that. The right to life. You know, if you look at Nazi Germany, life meant nothing. If a Nazi officer wanted to kill someone, they could do it. So the right to life is basically a victim right. Every human right builds onto another right, which is built on someone that was victimized, and the world said, we can't do this anymore. So an ideal justice system would be socially constructed. It would be based on universal human rights. It should be adaptable. The problem with the current criminal law system, doesn't matter whether it's Roman, Dutch, or civil, is it's very rigid. For a law to change, you have to have parliament, and sometimes that takes too long, right? So it needs to adapt. As society changes, it needs to adapt and be able to quickly adapt. I mean, if you look at cybercrime and cybercrime victimization, the law has not kept up with technology. Criminal justice has not kept up with technology. So there's cyber offenders that will not see the inside of a courtroom because there's no laws making what they do illegal. And you can never have a retroactive law. So some of these guys will escape the concept of justice completely. Then law should embrace new technology. And we saw this happen. We saw this happen during the pandemic. Do we really need big courthouses? That money we spend on courthouses, why can't we use that money and have smaller regional court setups where you have a judge on a Zoom meeting and the defense and the prosecutor also in the Zoom meeting? I mean, this is what we did during pandemic. South Africa, a lot of the cases went via Zoom. And I assume in Indonesia as well, because we couldn't meet in person. Suddenly, you could have a judge in a Zoom meeting. You could have the offender and the defense on the one side, and it worked. Yes, there were some glitches in the beginning and people trying to get used to it. But look how quickly the justice system can actually adapt if forced to. So we should not, now that we're slowly moving out of this pandemic, throw that away. I would argue that the use of this new technology, Zoom, actually opens up justice more for society. You know, it's difficult sometimes to go sit in a courthouse. It will help victims that they don't need to leave their homes and be confronted by an offender in the courthouse themselves. You sit at home, you log in, you give your testimony without having to see the person that maybe have raped you or have abused you. So it's such a new technology, but it can open up justice for so many, and it's also a lot more cheaper. Then at the basis, the building blocks for a new post-pandemic criminal justice or law, it should be victim-centric. I mean, the idea that we call something a criminal law, it shows you that the most important aspects in such a criminal law is the criminal or the criminal offense. But the idea that Beccaria had when he wrote on crimes and punishment was to protect the victims. So it should be victim-centric. And here I can refer you to a system in Germany called the Nebenkläger system, where you have the offender, you have the prosecutor, and then the victims can also have a lawyer representing them. So the victims can ask questions during the court case to the offender, to the defense, to the prosecutor, and thus their voices are being heard. And then when it comes to the other major foundation of a new justice system, we should incorporate a lot more restorative justice principles. I just came back from the World Society of Victimology's symposium in Spain. And a lot of the papers and presentations during this symposium was on the practical application of restorative justice in different formats, with different types of victims and with different types of offenses. So it's not like we cannot use restorative justice. It's up to our own understanding and our creativity to help construct a justice system that is really just and is based on the principles of equality and fairness. And did I make it in time? Thank you.
Time's up, Prof. Okay, Prof, thank you for your time. I'm sorry. Test, test. I'm sorry, Prof. Technical problem. Okay, thank you, Prof. Your time is past. Okay. As I noticed, there's some notes that you have explained how the law play a role in ensuring economic stability in South Africa. And you also mentioned about the ideal justice system should based on universal and human rights and should be adaptable. It's a good, for me and maybe for the audience, it's a good insight. Okay, thank you, Prof. Jeko, again. We are moving to the next speaker. We have Dr. Edmond Makarim, Eskom SH from Universitas Indonesia. Hello, Prof. Hello.
Halo, Assalamualaikum, selamat pagi.
Waalaikumsalam warahmatullahi wabarakatuh. Selamat pagi. Before we start, I will introduce you briefly. Let me share your first. Share your CV. It's okay if you have already shared your screen. I will tell the audience about the brief CVs of Pak Edmond Makarim. He's a dean and a lecturer in a telematica law, cyber law FAUI, and also a senior researcher in a research law and technology. he graduated from Universitas Gunadarma in 1993 and also took his master in Faculty of Law, Faculty of Economic Law in Faculty of Law Universitas Indonesia in 1994, and he graduated from University of Washington School of Law, Seattle in 2004. Also take his doctor in 2009 in Faculty of Law, Universitas Indonesia. He has many experience of organizations and has published many books that you can saw. Maybe committee will share the CVs for the audience after the session. Okay, Prof, without further ado, so please, 15 minutes is yours.
Thank you very much. Good morning. Assalamualaikum warahmatullahi wabarakatuh. Salam, Om Swastiastu, Namo Buddhaya, salam kebajikan untuk kita. Apakah suara saya cukup terdengar dengan baik? Bu Moderator?
Ya, jelas.
Thank you. Thank you for the invitation. It is honorable for me to present these topics. And the honorables, our rector, Professor Jamal, Professor Yunus as a Vice Rector, Honorable Dean, Professor Ayu, and the Vice Dean, Professor Pujiono, and other colleagues, and other speakers that I cannot mention one by one in this forum, but it not means I don't respect the other speakers. So please, I start with this slide first. It represents and quite have connection with the professor, the previous speaker before me, Professor Jacob, yeah, and also professor from Malaysia, regarding the opportunity of micro corporations and also about the social justice. And some theoretical of justice had already presented by the previous speaker. I would like to remind in our constitution, there is a mandate for the younger generations. The governments built by our founding fathers in order to protect our nations, to give a welfare, and also to make our people become smart, right? And then there is a condition now, parallel with the evolutions for the industry. We could say that there is a new era for us, not only industry 4.0 and society 4.5.0, but also the intelligence era. Now, everyone, it seems like unaware that we are all under profile in the intelligence era. Everybody try to know someone more rather than previous era. So in this intelligence era, every people could be categorized as the information society. The people that realize data to be processed to have an information, and after that reaching another stage for having a knowledge, and then after based on the knowledge we make a decisions based on our wise. So in this intelligence era, the surveillance, it seems like daily is not cannot be apart from our daily life. So, but we should have a noted that the profiling and the surveillance, it should be restricted in the people that have a freedom in their daily life, even though through electronic system. So I quote the Bloomberg News this day, talking that Indonesians have fastest growing digital economies. But based on the research from my colleague from Faculty of Economic from University of Indonesia, saying that biggest platform in Indonesia that representing the UK micro and small companies transactions, actually they are not original Indonesian indeed, because the Indonesians micro company actually is importer from the China's product. So yes, for the transaction maybe contracted by Indonesian citizens, but actually the goods, the product from the micro small company originally came from China. So there is a critic from me to the jargon from the government regarding digital economy. So I try to remind us about these two words, digital and economy. So the definition of digital economy, we could say that is how we use the ICT boost our economy based on the existing industry, and we accommodate the new industry such as ICT product that are programmed in derivative models such as Internet of Things, which sell the IP address. Big data, it's almost general application regarding the big data, cloud computing, artificial intelligence, blockchains, smart contract, etc. And most of the resources based on digital resources. And there is two paradigms saying that it looks like the existing system lack of the technological development. So we could say that is seems that existing legal system not reasonable. But actually, the other perspectives, the other paradigm from the experts, I quote the justice from United States, say Brent Justice Frank Easterbrook. He reminds us that we're not talking about the new law indeed, but basically we talk about the digital property and the law of a contract. Yeah, so in this format, we could say that the essence of the metaverse cyberspace is actually based on how we transform our business process, the existing business process, transform to the engineering process. But unfortunately, some of legal experts saying that it looks like how in English word terlalu mengagumi ya. It's too admiring the technological product only, but forget to explore based on the essence of the technology. The technology is the knowledge of a human for solving the problems, representing based on the method, techniques, and equipment. So the engineering process represented by product, business process represented for the existing condition. So ideally, the engineering process is equal as with the business process. So some of the experts saying that disruption. So I think the appropriate word is to transform, because we should make this underlying process go to the engineering process. It's not vice versa. And digital resources, the first digital resources that we use, it's the signal wave. So the transformation from the analog, the sinusoidal wave, go to digital, make some technological development. So previously content based on voice only, now text, voice, and video. But this system operating based on the computer program. So the other code, the first code is the signal, and we use encryption product. After that, we use operating system such as Microsoft, Linux, and Apple. So the software, some of the operating software release their source code. But for the proprietary software, they not release the software, the source code. So people only use in the object code. So there is a risk since the beginning if we use the electronic system. Historically, this electronic system based on the Cold War situation. And that in that era, United States have win the war by using internet. So the internet, the simulation of internet is changing from the security to secure communication to the unsecured communication. Unsecured communication over us about the speed, but not the secure of the content. So since the beginning, the internet is a weapon, and the internet is facilities to explore the information and communication from others. So the big question for this electronic system should be trust and secure. So that's why the cybersecurity now is the hot topics for all countries. So, and the key of this system, if we could say there is a neutral technology for us, is how we make this system should be trusted. So it means everybody should pay attention for the security holes. And there is a liability and responsibility from any corporate to deliver the system to the public for their products. So it's, these opinions might be not popular for people, particularly for industry and trade people. But for the consumers, this is key for us in order to have our rights, secure, clear information about the facilities that we could use for the transactions. So the elements of digital economy, such as I mentioned like this in this slide. So what is the challenges for us? There is a big opportunity and there is a good number in statistic. Indonesia have potential welfare to get if we going to digital economy. But that legal reputations, it also lead the phenomenon. So if in the future we not have a good justice and do not implementing the social justice in this context, I believe that we are so too optimistic about the new digital economy, but not representing our welfare actually, because there is research from my colleague showing that even though there is a big number, it might be not from our product, not from our services. So the legal system in Indonesia, the first law that we should remind to explore is the law of EIT, Electronic Information and Transaction 11/210, and also law number 11/2019 about the knowledge, the science and technological system, national system for science and technology. And also there is some related laws related to the product of the technology, patents, copyright, industrial designs, and also the law of the industrial, law of trade, law of economic creativity, economic, and then consumer protection, and also unfair competitions. And there is a special power for governments. They have a preempt power to facilitate and to protect the people interests. The government have a compulsory, have a liability to prevent the dissemination of the illegal content, or any activities that might be not good for the people. So in order to explore to what extent the trust should be derived not from the branded, but from the clear information to the people about the risk and to what extent the corporate or governments had already mitigated the risk. In order to have a clear framework to what extent the liabilities because of the risk, we could explore from the administrative regulations, which represent about ex ante liability from the standard safety regulation and good governance. To what extent the IT system, the electronic system, accountable for the people. So that's why there is a government regulation have a mandatory to register the electronic system before going to Indonesian people. So we also have some regulation to regulate about the tort law and how we implement the principle of the liability in this context. Because the consumers do not have a power, do not have a knowledge to prove if the electronic system working not properly. So that's why in this law, we implementing the presumed liability. And in certain conditions, there is a room, there is an opportunity for the judge to implement the strict liability, absolute liability for the electronic system product. And we had already legal provision, particularly in Article 15 of law of EIT, regarding the good ICT governance. There is an accountability based on 3 criteria. The first criterion is handle is well designed. The system should be well designed, secure, including logic and physical. And the third one is working properly. And then it become a liability for all of us because in the international fora, the cybersecurity might be tend to the conflict between states. And there is some consensus regarding this that we implement in multi-stakeholders perspective. So that is almost impossible for the one agency can handle all of the situation incidents that might be tense not only for the perspective for civilians, but also from the military. So that's why cyber operation behind of the electronic system should be guaranteed from any other country. So that's why there is a manual. This is NATO format, cyber operations. So there is a big debate to what extent we could say the cyber attacks as equal as the armed attack, and it might be tends to have an action, retaliation action or countermeasure action from the victims. So even though there is an opportunity for small medium enterprise to get economic value from this electronic system, but we should remind all of us about the security aspect, because in the security, it could be classified as liability of the nations. National security, in our constitution, saying not only right, but also our liability in order to join and to participate actively for the secure system for all the people. And this is some of the provision had already accommodated to a law of EIT on cybercrime aspect. But if the system, the vulnerability of the system, its vulnerability of the ICT product and services, it's almost impossible declared by the corporate. So that's why some organizations should be aware that if the vulnerable do not clearly defined or clearly declared by the vendor, by the operator, that might be a big risk for all the people, particularly for the users. So if there is condition like that, we could say that the government should give trusted list to the people, because we could not say that all of the information, all of the system is trusted in the internet, because since the beginning there are inherent lack of security. The security protocol ideally is 7 layer, but internet only 4th layer. So they overspeed, but they're not over secured for the users. And the second issue, so the hottest issue of the cyber law, is the privacy. To what extent that privacy has been protected, because in this connection, cross-border, not only for the corporate, but also state and individual citizens. But some of legal experts saying that it's not protected yet. But if I refer to the law of human rights, since 1999, we had already data, personal data in our law. And in this context, it means tidak boleh jadi objek penelitian. It looks like not have a rights, do not have a profiled activities from others. So it also had been declared in Article 26 in our law of EIT. One of the privacy right is rights do not been exploited or do not been profiled by others. You could read this one, tanpa kegiatan memata-matai or spying from others. So even though we do not have a special law for personal data protection yet, yeah, but actually it has been regulated, distributed to the existing legal condition. So if we refer to the law of the IT, derived to the government regulation number 71, 2009, and also the law number 18, 2019, about the government regulation on e-commerce. So some of these, some of the principles refer to the best practices had already been adopted to our law. And also the government administration, the trade, yeah, and also the consumers. So in short, every medium, small, medium enterprise, SMEs, corporations, they can have an electronic contract. But be aware that some basic principles of the legal requirement regarding electronic contracts is almost the same with our civil code. You can see from this the clear information before someone have a decision to give their consent. Okay, I see that a moderator had been touched the microphones. It would like to remind me about the minutes, yeah? So I ask for the 1 minute for the closing statement. So at the end of electronic communication for contract, it might be have a purpose for evidential purpose. So in order to have evidence, there is a liability for the corporation about the availability of the contract and also the authenticity of the contract. And regarding for the public services and cross-border document for facilitating international contract, we had also rectified the agreement 1961, the convention, Hague Convention for abolishing the legalization of foreign public document for international contract. So all of the legal development in Indonesia seems on the good track. But we still lack of one topics regarding to what extent we have a clear legal framework regarding national electronic authentication, because its communication for contract should have electronic identification and authentication system. So the cyber notary also the answer for the futures for Indonesian development in order to have their welfare in digital economy. Thank you very much. Lebih dan kurang saya mohon maaf. Forgive me if I have some appropriate maybe unpleasant situation. Thank you. Back to the moderator.
Thank you, Professor, with your explanation about the cybersecurity issues, and you have explained about the list of our IT law and cybersecurity provisions. Also mentioned about the law of privacy in our country is still overlapping and fragmented, I thought. It's an interesting topic, Prof. Thank you very much. I hope that you can share your material, your subject matter to us.
Yeah.
Yeah. Thank you very much.
I had already sent to the committee.
Oh, thank you. Thank you.
Okay. Thank you.
Okay. The next speaker is coming from Universitas 11 Maret, Professor Budiono Esa MH. He is Vice Dean in the Faculty of Law, and the latest achievement is become the youngest professor in 11 Maret University in 2019. Okay, please, Prof. Budiono, 15 minutes is yours.
Okay, thank you, Bumi. But at the time, I'm not the youngest professor in UNS.
But it's good.
Okay, Professor
Good to hear that.
Okay. With I respect and be proud, Prof. Jamal Wibowo, Rector UNS, that is represented Prof. Yunus as Vice Rector of Academic Research and Student, and also Prof. Igusti Ayu, our Dean, Faculty of Law UNS, and respected all great speakers that have attended from this international webinar, Prof. Edmond Makarim, Prof. Ceko, Prof. Kusriatin from UNER, Prof. Tutianlu, and Prof. Suryati from UUM, and also Dr. Umi Herapati as moderator on international conference in this morning. And also for all of committee that had prepared from this webinar, thank you and good job. And all of participants, have a nice day and good morning. Assalamualaikum warahmatullahi wabarakatuh. Let me share my PPT. Okay. Okay. I should make this is the big full screen. Okay. So after COVID-19, how the direction of the development of economics law in Indonesia, I make a relation between SDGs, Sustainable Development Goals, and micro, small, and medium enterprise in Indonesia. How about COVID? Actually, there is a daily trend COVID conversation. This data I took from Drone Emprit Twitter. Maybe Pak Edmond familiar with Mas Ismail Fahmi. Yeah, I took this data from him. The mention from online news, Facebook, Twitter, YouTube, Instagram, but the notable, the blue line and green line, The blue line is from Twitter, and green line from online news. So from April, yeah, from April to 2020 to October 2021, the volume of mention compensation on Twitter is higher than online. Normally, for an important issue for netizen, it would be like this. So we know that this data we can see in May 2020 and increase again in July 2021. But however, since October 2021, the media that is more busy reporting about COVID-19. On the other hand, netizen mention less volume. This means that netizen are not too concerned about the COVID issue. Netizen version of back normal is officially start happening since October 2021. So COVID, I think, really important, but it's not important for netizens. But actually, COVID gave bad impact in many business. Yeah? How about Indonesia? Indonesia as the presidency of G20 as an organization consisting of 20 global economic powers is considered capable of contributing to restoring the world economy after pandemic. In addition to economic recovery after COVID, have another important agenda to accelerating the achievement of SDGs, Sustainable Development Goals. Post-pandemic economic policies priorities on sustainable development. In addition, it is equally important to open up job opportunities in the digital sector, like Pak Edmond said previously. Furthermore, driving productivity to create value in the new sources of economic growth, creating economic system more livable earths, and more adapting or receiving more people to get a job. So SDGs government policies that are for micro, small, and medium enterprise. Okay, how about SDGs? Yeah, SDGs. SDGs actually previously we know MDGs. MDGs are global development paradigm declared by United Nations in September 2000. All countries present at the meeting committed to integrate the MDGs as a part of the national development program. So MDGs launched in 2000 and completed in 2015 has 8 goals: tackling poverty and hunger, achieving primary education, encouraging gender equality and empowerment, reducing child mortality rate, improve maternal health, combating AIDS, malaria, and other infectious diseases, ensuring environmental sustainability, and building a global partnership for development. So there is SDGs completing MDGs. MDGs has 8 goals, 18 target, and 67 indicators. How about SDGs? SDGs has 17 goals, 169 targets, and 241 indicators. So what about completing? SDGs completing MDGs in 7 categories, more comprehensive, involving all countries with universal goals, 0 goals, aim to complete all indicators. All indicators have 2041 indicators, emphasize of human rights, inclusive and no one left behind. So this is the important one, inclusive and no one left behind. This is the principle, but the practice we can as in next step, yeah. Involving all stakeholders, governments, CSOs, media, philanthropists, business, and expert on academics, expanding fund sources, government, private, and other sources, and mean of implementation. So actually, this is the one important means of implementation. This SDGs, yeah, SDGs consists of 1, 2, 3, 4 pillars: social, economic, environmental, and legal development and governance pillars. This Indonesian commitment in implementation of SDGs. So we have 4 commitment. First, Indonesia is committed to implementing SDGs for the transformation of global civilization. Second, this commitment is realized by President Decree, Peraturan Presiden number 59 year 2017 concerning of implementation of achieving SDGs, and then SDGs in line with Nawacita, and which is translated into RPGMN to realize a sovereign, independent, and sustainable Indonesia based on mutual cooperation to achieve Indonesian noble ideals. And fourth, the President will continue to monitor the implementation of SDGs. How about the legal governance in Indonesia? There is a peace, justice, and strong institution. This is the goals of legal development that relate SDGs. I took from Bappenas, National Development Planning Agency. This is the strengthening inclusive and peaceful societies for sustainable development, providing access to justice for all, and building effective accountability and inclusive institution. There's many indicators, yeah. Indicators, okay, is the indicators. Okay, nah, how to reach the indicators? Actually, we have Pancasila as a ground norm, as basic values. Non-positive things that exist in Indonesia and become the basis for every ratio that the state will issue. Indonesia, after Pancasila, turned on to Constitution is our groundwork, Undang-Undang Dasar Susup 1945. The concept of the rule of law is regulated in Article 1, Paragraph 3, which states that the state of Indonesia is a state of law, negara hukum, not authority of state, yeah, the authoritative state. The Constitution is a written source of basic law that regulates state affairs. And the concept of a state of law for Indonesian people is the absorption of substance from Rechtsstaat, continental Europe, and the rule of law Anglo-Saxon. So we can make combine between common law and civil law in Indonesian regulation. Now, how about the goal? Our regulation have goal people well-being, sovereignty. Sustainable development is a process to meet human needs at the time without sacrificing meeting human needs in the future. In other words, continuing without lessening, developing or running without lessening. In our constitution, there is the goal that's creating a just society and prosperous, materially and spiritually, and so on. This is the notable our goals in our constitution. So how about SDGs? Actually focus in three aspects: economic and law relation, social and law relation, ecology and law relation. In economic, I think SDGs so ambitious, yeah, ambitious. Why ambitious? Because SDGs has many goals. There is 17 goals. How about in micro, small, and medium enterprise? So we should really make it. Make it SDGs like a beyond, but micro, small, medium is the real business. So at the same time, they will be not meet. They will be not meet. Okay, I will follow. There is the problem. Law and economic often do not meet. Economic choice, human tend to calculate transactional cost. This is the economic principle. The economic principle. Following the law, limitation in achieving goals are often a problem, or this is the consequence. This is where law and economic, I said previously, maybe not meet. Yeah, maybe not meet. Market performance describes the efficiency of the market in using resources to meet consumer demand for goods and services. So if we talk about efficiency, in question is how well a market can contribute to the optimization of economic welfare. Ken Kohn, like an Adam Smith theory, the perfect market. Adam Smith say about the invisible hand, So in the theory of Smith, that Smith say about making less state intervention in the market, or not less, just but should menghilangkan state intervention. But we know the problem, like the case Luna, Terra Luna, yeah, Terra Luna. This the form of crypto asset developed by Terra in South Korea. Do Kwon is the creator. He started working this project 2018. He wants to develop a cryptocurrency, and that is resistant to price volatility, balance. And this crypto asset are non-stable coins. But there is the problem. There is the problem. Terra was created with the aim of forming a new compact payment tool and replacing the complex payment value chain. For example, credit card, network, banks, gateways. All payment will be made with the single layer of blockchain. But there is the problem after the value of Terra decreased from the 100 to 0 rupiah. This is the problem, and the amount of the asset of Terra that's decreased. This a big, like we know the crisis in 2008, 2008 in America, and the same amounts. But why Terra not have a big impact less? Like the economic crisis in 2008. This, I think, the problem. So how about the small, micro, small, and medium-sized enterprise in their role in achieving the SDGs? The SDGs target, I said that previously, SDGs target are ambitious, and there are required transformation of public and private activities. This transformation is associated with adapting new business model, bringing in new innovation technology and doing business differently, more sustainable and more ethically maybe. This process opens up new business opportunities for the private sector in general and particularly for micro, small, medium enterprise. Mikro, kecil, menengah, menengah. According to the Business and Sustainable Development Commission, actually MSMEs, micro, small, and medium enterprise, could open economic opportunities. Yeah, worth it in maybe in Indonesia maybe 400 billion rupiah. Driven by SMEs, but the regulation still not directly push the progress of MSMEs, micro, small, medium enterprise. I mean, the business development in this sector actually doesn't need rigid regulation. Regulation must be flexible, able to follow and adaptive to the dynamic of economic and technology. Now, if we agree about the theory of Bentham, law as a tool of social engineering, and this the goal of all of our regulation to make a welfare of society. But if we relate with economic development, so we can make our regulation in economic should follow the welfare society. Okay, how about the resolution? I mean that the resolution, we need government intervention. Well, it is limited, it's okay. In SDGs, there is three things that should government give. One, profit tax relief, credit relaxation, make licensing easy. How about tax relief? Actually, we have law number 7, 2021 concerning on the harmonization of tax regulation, which applies this regulates the exemption of PPH, pajak penghasilan from micro, small, and medium enterprise, but the offset less than 100 million in 1 year. So this is the difficulties. I mean that the policy must be, the amount of the policies must be increased, maybe until 700 or 1 billion. It's okay. The policy I think good, but the amount must be increases. And how about the credit relaxation? We have peraturan OJK, Financial Services Authority, issue about national economic stimulus as a counter-cyclical policy for the impact of the spread of COVID-19. That previously OJK believes that this pandemic has great potential disrupt in banking performance and financial stability, which in the end will hamper economic growth. So OJK make this regulation, peraturan OJK about counter-cyclical. Based on this regulation, OJK provides special treatment to debtor to debitors who are directly or indirectly affected by the COVID-19. But in practice, this POJK is barred. It is rare for bank to apply because of losses with the threat of bad credit. This make solvability in bank not good. So many banks not in this day many banks not applying this regulation. How about the easy licensing? Actually, since the year 2018.
Interrupting you.
Okay.
Time is up.
Yeah. 15 seconds. Yeah. We have the platform, known OSS, online single submission, and this is applied to micro and small business. This is good, and the government should be increasing these policies. I think this is all my presentation, and thank you very much for your attention. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Prof. Puji, for sharing about SDGs as an Indonesian commitment that focus on economic, social, and ecology, and also law relation for SME development strategy, and also mention about the resolution. Thank you for your knowledge sharing, Prof. Next, we are moving to the next speaker. Let me share you the CV. As you look on the screen, his name is Professor Hatian Lu, LLB, LMM, PhD, a professor in Law and Finance, Director of Chinese Mainland Affairs Office, currently at the Hong Kong Polytechnic University lecture. Oh, Prof. Kus. Oh, I'm sorry. The next speaker is Prof. Kus Yanti. I'm sorry, I will stop the share and move to the next. Okay. Okay, the next speaker is Professor Kusrianti SILM PhD. She is a professor from international law in Erlangga University. She graduated from UNSW University in Sydney, Australia, for PhD in 2005, and for master also in University of New South Wales, Sydney, Australia in 1997, and she took her bachelor in a Bachelor of Law University Erlangga in 1985. She also have awarded from some scholarship and award, like awardee of Australian Development Scholarship in 1997, funded from Australian government, and awardee of Australian Development Scholarship also for doctoral program, funded from Australian government, and has awardee of Satya Lancana Kesetiaan Loyalty Award for 20 years of Indonesian civil servant from Indonesian government, and ASEAN Law Academy Fellowship, Center for International Law, National University of Singapore, CILS and US. Currently, she's a head of international department and was the director of Erlangga Institute for International Law Studies. was Vice Dean for Finance and Resource, and so on and so forth. Here, her publication and also research experience and so on and so forth. You can show on your screen. It's too many, so I can tell you one by one. So please, Professor, time is yours for 15 minutes. I'm sorry, your microphone still mute. Professor, can you hear my voice? Your voice is not here.
Sorry, I still unmute.
Oh, yes.
Thank you. Good morning. I have to address some people. The honor Prof. Yunus of Vice Rector of UNS, and then the Dean, Prof. Gusti Ayu, and the distinguished speakers and dear participants. This is honor for me to be one of the speaker in this international law and webinar, economic webinar. Thank you. And this is my my title for my presentation. This is my outline. So I will talk about the pandemic at first. I will compare this pandemic, the COVID-19 crisis, with the previous crisis, and then the post-COVID-19, the role of the MSMEs, and then the characteristics of the MSMEs as the economic backbone of the countries. And then this is the important things, I think, the omnibus law and the implementing regulation. And then I will conclude my presentation. I will quick with the presentation. This is the previous global crisis. As a comparison, we still experience, we still remember the financial crisis in 1998. That one is ASEAN financial crisis, began in the Thailand and then quickly spread to the neighboring countries. This is purely currency crisis because caused by the collapse of the currency exchange rate and hot money bubble. And then we also still remember the economic crisis in 2008. Different with the crisis in 1998, this crisis in 2008 is global financial crisis began years before with the cheap credit and tax lending, standard, and fueled by housing bubble. So we still remember the subprime mortgage. This has led to economic crisis. So both of the crises, all are purely economic element. And then we are experienced with health crisis, call it SARS in 2003. SARS 2003, severe acute respiratory syndrome or SARS. 7 of the 10 countries affected with the cumulative number of cases are in Asia. The mainland China, Hong Kong, Taiwan, Singapore, Vietnam, Philippines, and Thailand. This crisis is end in the 2004. It's not really affected. We didn't affected by this crisis, but the 7 countries in the Asia were affected by this crisis. Infected over 8,000 people from 29 countries. The cases are 8,096 and the death 774 people. How about COVID-19 crisis? Compared to the previous crisis, the COVID-19 crisis is a combined between economic crisis and health. And then this the combination of the crisis, economic and health, lead to the social crisis. This crisis is unprecedented global health and social economic crisis. Means that this crisis is never happened before. This is a new, and then that's why the people is surprised with this crisis, because the virus is spread very quick, and they are million victims. Started from December 2019 from China, and then quickly spread to the worldwide. WHO, the International Organization for Health, comments the public health emergency of international concern, or PXEI, on 30th of January 2020, and then on 11th of March 2020, the WHO declared that this is pandemic, means it is a dangerous virus, because the pandemic is will spread in the countries in the world. As July 2022, right now, we can find that there are more than 567 million cases, and confirmed deaths, there are 6,038,000 people. This is the death lies in history. COVID-19 easy to transmit from people to people. Why? Because nowadays is a globalization. The transportation at that time, 2 years ago, is very easy. You can move from one country to another country. It's very easily. That's why the spread of the viruses is very quick, very fast. And then the problem now is post-COVID. How the countries can recovering their economic from the crisis. So the pandemic lasts for 2 years. 2 years pandemics is enough for us to, like, for the national economic to collapse, because there is a policy about large-scale social restriction. We have social distancing policy, so we cannot go out from our house for more or less 2 years. And majority countries at the time, in the last 2 years, they shut down their doors for foreigners. So this is become the crisis, the global economic crisis. The economy in worldwide is slowed down. especially tourism and tourism industry and hospitality sector, they collapse. And then post COVID-19, what should we do? Oh, we should do economic recovery. Yeah, the government should do economic recovery. This is will the central for every government agenda. And in the same time, the government should stop the spread of COVID-19. So there are two agenda for the government, the economic recovery and stop the COVID-19. So the creating economic recovery and growth post COVID-19 depend on how well the pandemic continues to be controlled. So how well the Indonesian government to control the spread of the pandemic or the viruses, the efficacy of fiscal policy in mitigating economic damage, and global financial condition. And I can say that the business are the engine of the economy, including the MSMEs. Government should create an environment and structure that enable enterprises to flourish, because there are a lot of, or there are so many companies that collapse, that they finish their operation. So for the recovery national economic, it should be a combination of policies and hands-on program focused on domestic economic strength, domestic economic strength. It should be have a clear guidance. National regulatory environment is robust, and national industry and business are seen as part of government broader policy apparatus, and social services programs are subsidized and targeted, and national and local issues are considered a higher priority than global challenges. So I will elaborate more on this combination of policies. But before we go to the themes, topic, we will discuss about the SMEs as a backbone of Indonesian economics. The history shows that in the international, in the financial crisis in 1998, SMEs at that time could exist. They resistant from crisis because the crisis is purely economic. But in this COVID-19 crisis, the MSMEs is the victim of the COVID-19. So I would like to say that the MSMEs should develop into scalable business. They have to enhance their economic capabilities, because they are essential for economic in Indonesia economic growth, especially in the post-COVID-19. And we can see in Indonesia goals in 2030 that Indonesia will predicted as a world's 7th largest economies. This is the total number of SMEs. Actually, the total enterprises in Indonesia are 64 million something, and SMEs are the majority of enterprise in Indonesia, because 90% of enterprises in Indonesia is MSMEs. The large enterprise only accounted only 1%. And then the beauty of the MSMEs is that over 60% of GDPs of Indonesia, and then they are absorb more than 100 million people, or 97% of domestic workforce. So we can say that MSMEs are the major player of economic activities market in Indonesia. This is the characteristic of MSMEs. We can challenge what is the small, what is the medium enterprises versus large enterprises. What is the treatment of the government towards SMEs compared to the treatment of government to the large enterprises. Unfortunately, there is no common definition of SMEs, but in practice, we can differentiate between micro enterprises or ME and SMEs. On the other hand, with the large enterprises. And then the terms become MSMEs, or micro, small, medium enterprises. And if we want to, what is the definition of SMEs? We can see in the definition provided by World Bank, micro-sized enterprises is a firm with 1 to 9 employees. They just have 1 to 9 employees. And small enterprises, they only have employees from 10 to 49 people. And then medium enterprises, they have 50 to 299 employees. And large enterprises is the firm that have employee more than 300 people. This is definition from the World Bank. And then the definition from the European Union, it's similar with the definition of World Bank, but in the European Union, they added the turnover of the companies. In ASEAN, because ASEAN have 10 different 10 member, so we will have 10 different definition and criteria. So this is only an example. In Singapore, SMSE is a business with annual sales turnover of no more than 1,000 million Singapore dollar, or employing no more than 200 employees. I will show the weaknesses of MSMEs in Indonesia in particular. This is the weaknesses of this our SMEs. They have limited capital, and they have limited human resources. They have limited technology, low productivity, low managerial skill, poor business environment, and majority of business is informal. Yeah. See, in this year, in this slide, we can see that as MSME in Indonesia, the majority are in the informal sector. There are 285 until 345 million compared to 70 to 100 million formal sector. So this is our homework, how to enhance the capacity and capability of MSMEs in Indonesia. Meanwhile, the aim of empowerment of MSMEs is to better national economic structure. So we would like to balance, we would like to have a balancing between the SMSE with the large enterprises, and then we would like to develop an a fair SMSE that strong and independence. And then we would like to enhance the role of MSMEs in the local area development to create employment, sustain income, economic growth, and eradicate poverty. So we have now omnibus law. Yeah, I can say that this omnibus law, spoil SMEs and cooperative. This law has aimed to empowerment and protect the SMEs and cooperative. This law, number 11, 2020, this law create centralized business licensing system and simple procedure. We can see that SMSE now can have their license only for 2 until 3 hours, the processes. So when they have this business license, they will have a bank access. So this will boosting their economic capacity. And then government provide SMSEs raw material, production processes, enhance human resources, product marketing. This is the strategy. Actually, we prioritize local economic recovery. So we concern with the supply chains for vital industries at risk, have high level of domestic inequality or disgruntled citizen. In the same time, we have like a globally oriented recovery. So omnibus law have implementing regulation. We call it government regulation or peraturan pemerintah number 7 2021. Actually, this regulation have a greater protection and empowerment to Indonesian cooperative and MSMEs. New protection and empowerment measures for SMEs. Before we go there, I will show you the new criteria under this regulation. So because the SMEs is categorized as a business, the criteria for SMEs, the new one is based on their business capital and annual sales. So exclude land and building. I will skip this criteria. We will come back if we have time. Yeah. Basically, the criteria is new. Basically, the criteria is increasing the annual sales from small SMEs than previous regulation. And then there are some facilities for MSMEs under the new law. The government will provide technical guidance, consultation, and training to increase their knowledge of national standards such as halal certification, other regulatory certificates, and etc. And then the government also financing and give incentive to SMSE. In here, there are 2 facilities for SMSE. They are able to use their business activity as a form of credit guarantee to obtain financing from bank, and their tax administration process has been simplified. And then the other them are regional tax reduction or relief, regional fee reduction or relief, subsidized loan, capital for SMEs with innovative products that have market potential or are technology-based. So there are a lot of facilities that provided by government for them, including financing of intellectual property right, vocational training, support for research and development, because these are weaknesses of this SMSE. And then this is important one. The government can act as a guarantor for up to 80% of loan or financing of SMSE. This is the criteria of SMSE that has to fulfill to get this to get the facilities. So they have to have a business operation. Gross income is no more than 7.5 billion rupiahs and etc. Yeah.
Time.
Okay. I will. Okay. This is can discuss in the Q&A answer session. So this is a conclusion. The Omnibus Law actually increasing investment for especially for SMSE, and then providing direct capital injection through investment, loan, and grant, for injecting capital into the banking system, and then increasing activity through public-private partnership structure, and attracting incoming foreign direct investment, and stemming of loss of outgoing FDI. Thank you.
Thank you, Prof.
Yes, I can.
Yeah, thank you, Professor, for the explanations. You have mentioned about some overview about 10 different concepts of SMEs in some countries, especially Indonesia, and introduce some regulations related to SMEs, like on Omnibus Law, and also have mentioned about some relaxation regulations during the pandemic and after pandemic in Indonesia. Thank you very much, Professor. We will next maybe ask you in the question and answer session. Okay, we move to the next speaker, Professor Hetchen Lu. Hello, Professor. It's nice to meet you again.
Hi. Hi.
Hello. Before we start, I will share your brief CVs for introduction. Wait a minute. Yeah, Professor Hetchen Lu, LLB, LLM, PhD, Professor in Law and Finance, Director of Chinese Mainland Affairs Office, present at the Hong Kong Polytechnic University. His experience, he is Director of Chinese Mainland Affairs Office from 2020 till present, and was Associate Dean, Faculty of Business, Associate Head, School of Accounting and Finance in 2012 till 2017, and so on and so forth. You can see in how to say the screen. His educational background, he graduated from National University of Singapore and US in 2007, supervised by Sundarrajo for his PhD, and for his LLM, he graduated from University of Liverpool, UK in 2002, and LLB in Nanjing University in China, Faculty of Law in 2001. You can see his research interests about law and finance, corporate governance, and corporate social responsibility. And his experience about teaching, researching, and communicating services. Maybe you can see his CVs that shared by the committee later. Okay, it's too much, Prof.
Thank you.
Okay, time is yours, Professor. Please.
Okay. Okay. Thank you, Yumi, for your kind introduction. Actually, I'm an old friend of UNS. I actually have a presentation video. I assume that you have it, right? So I will first introduce a bit orally on this research project, and then I will play the video. Okay. So distinguished guests, my great honor to join the conference. I'm Haitian Liu, a professor in law at Hong Kong Polytechnic University. So my research team is currently working on this project titled The Tech for Social Good, Integrating Ethics into Artificial Intelligence Systems. So the motivation of this research is the profound impact of AI applications on human well-being and the societal development internationally. So despite the rise of many high-level principles and guidelines by countries, international organizations, and tech giants on AI ethics, there is a significant gap in turning normative discourse into standards, operationalized approaches, and ethics-informed algorithms. So we fill this gap by assemble a multidisciplinary team of world-leading scholars in law, philosophy, computer science, and we obtain strong support from industry partners with practical AI expertise. So this project will deliver a comprehensive capacity building outputs, including white papers, computer readable ethics norms, training data sets for domain-specific AIS models. So also ethics relevant case study, repository, management toolkits, classifying system, legislative proposals, and of course, evidence-based articles and reports. So to illustrate how we do this, our team prepared a video. So please enjoy. Yeah, thank you, Yumi.
Okay, please, the committee, play the video.
Dear panel members, thanks for the opportunity to present our proposal, Tech for Social Good, Integrating Ethics into Artificial Intelligence Systems. I'm Haitian Liu, PC of this project. AI brings humanity enormous benefits at the price of technological barriers. As human delegates more important tasks to AI, concerns over AI's impact on human safety, privacy, autonomy, welfare, and societal norms have mounted, leading to the global grand challenge on AI ethics. Ethical AI is central to the next generation accountability structures and of tremendous interest to both government and private sector. The challenge is to assure that AI works for the good of human and society and minimize its negative impacts. This project aims to place Hong Kong at the global forefront of AI ethics knowledge base and role model of international smart city by enhancing our society's capacity to tackle AI ethics challenges. The project will generate holistic solutions of legal, technological, governance, financial, and educational measures for ethical AI. AI ethics is an emergent area of excellence in its own right. It builds on the stock of vast human knowledge on how our society works and what disciplines unethical behaviors? The rise of AI creates new ethical problems. Some are attributed to human abuse or misuse of AIS. Moreover, highly autonomous machines may get wrong by itself, causing unintended negative consequences. Unfortunately, social science scholars rarely dialogue with computer scientists. There's a significant gap in turning high-level ethical norms into standards, operationalized approaches, and ethics-informed algorithms. Though academics are good at spotting ethical problems and make systematic inquiries, they lack technical know-how and practical experience. On the other hand, engineers, data scientists, and product managers know how to make AIS to achieve business goals, but they rarely think about ethics and lack the kind of training that academics receive. This project fills this gap. We assemble a multidisciplinary team of world-leading scholars in law, computer science, ethics, software engineering, culture and history, and business. We also obtain strong support from industry partners with practical AI expertise. Our action plan includes 8 interlinked tasks. Each task is an interdisciplinary project in collaboration with industrial partners. Task 1 aims to lay a normative foundation on the most commonly accepted principles of an ethical AI. Examples of such principles include transparency, fairness, explicability, responsibility, privacy, among many others. Through desktop research, we explore the connotation of each principles, their relative importance in specific domains, their interconnections and conflicts. Task 2 aims to test our society's value and attitude towards AI use, AI ethics principles, and the most pressing AI ethics challenges through public surveys and interviews. We will compare results from Hong Kong with those other cities in the Greater Bay Area. Mistakes and incidents are important learning opportunities to make AIS more ethical. Our third task is to establish an online incident case database for users and engineers to self-report AI ethics incidents, and we will write domain-specific case studies. Task 4 aims at building a classifying framework and ethics label. We first propose a standard description format for various AIS. We then use this format to form a classifying framework which identifies ethics-relevant characteristics to be the framework dimensions. We then evaluate and create ethics labels to each AIS. In Task 5, we form subgroups to establish normative baselines in selected domains. Based on pilot study, we choose 5 thematic focus. They are ethical AI in finance, mobility, healthcare, marketing, and education. In Task 6, each subgroup works with an industrial partner to evaluate a real AIS. We will perform a thorough ethics diagnosis that covers its settings and objective functions, data collection and preparation process, model development and management, and performance evaluation and accountability. Once ethics problems and courses are detected, we propose solutions that include legal, computational, governance, management, and other remedies. In Task 7, we collaborate with different public and private sector stakeholders to promote the impact of this project. We also plan to collaborate with international centers and institutes on AI ethics to publish joint research reports. To stay competitive in the digital economy and build a world-class smart city, Hong Kong needs to nurture its homegrown and ethics-informed data scientists, programmers, product managers, and business professionals. Our final task aims to produce world-class educational programs, which include an online resource repository, textbook, MOOCs, and training materials on AI ethics. Our project team members are leading scholars in their respective field. The team has broad and complementary knowledge. Cohesion is achieved through PC's collaboration history and social network with members. In the past 5 years, our team members have altogether secured over 820 million Hong Kong dollars in external research funding. We set up a governance structure with a project steering committee as advisory and supervisory body, a project management committee as the executive body, and task-based interdisciplinary teams at operational level. We divide the project into 8 independent yet connected tasks. This structure helps to leverage expertise and resources, define task force leadership and responsibility, overcome disciplinary barriers, and mitigate failure risk. Upon completion of this project, government, regulator, and policymakers will be better equipped with knowledge and tools to regulate existing and future AI ethics challenges, to develop ethics as a service as a new competitive edge for Hong Kong, and build the ethics infrastructure for a world-class smart city. Companies, executives, product managers, and engineers will know how to mitigate ethics-related legal, regulatory, reputational, and product risk. User consumers and the public will become ethics-conscious digital citizens. And we will nurture many homegrown, ethics-informed researchers, data scientists, programmers, product managers, and business professionals. The greater the freedom of a machine, the more it will need moral standards. We believe in tech for good. Together, we build ethical, reliable, and trustworthy AI for a sustainable future. Thank you for listening.
Thank you. Thank you for listening. I think I will leave more questions to the Q&A sessions, but I just want to summarize that. Of course, we highlight the key merits of this proposal, but we face, of course, many challenges. Okay, so the challenges are several-folded. Firstly is we try to integrate ethics into artificial intelligence systems. But on the ethics, actually ethics has been there, this subject has been there like more than 2,000 years, okay? So, and this is very culture dependent. So on this so-called normative baselines, different countries, cultures, and peoples may have different value differences. Okay, so even the simplest ethics norms, ethical principles can be subject to the different interpretations and practices. So here, I heard the earlier speakers this morning. So we are also trying to see whether we start with the universal values, such as those provided in the ICCPR, ICESR, and also we highlight the sectoral or domain-specific ethical challenges. Because at high level, it is hard to agree at abstract level, it's hard to agree on anything. But at the domain-specific level, we have more concrete settings, the objective functions, and it is easier to agree upon a set of ethical baselines. And secondly is on the technical know-how, okay? So on how to integrate ethics into AIS. To start first, that we do not expect machines to become ethical, okay? So machines are machines. They don't have so far, at least this stage, they don't have their own will, okay? So, however, to integrate ethics into AIS, we adopt both a top-down and bottom-up approach. So top-down means that for those ethical norms that are explicit and codifiable and we try to feed the computer with data and impose morally desirable rules to guide the computer and generate morally desirable outcomes. However, for those rules that are implicit or uncodifiable, then we adopt a machine learning approach and try to feed the system with data and morally desirable outcomes, and then let the computer to figure out the rules by itself. And then we pass new data to these rules and get answers for the new data. Of course, there are many more challenges ahead, and we are adopting a learning by doing kind of attitude. So we welcome your comments and inputs. So that's all my sharing. Thank you.
Okay, thank you, Professor, about sharing the big project. I thought this is an interdisciplinary project that integrated ethics into an AI system, and it's so very difficult. You know, AI has no ethic and soul. So yeah, but it's important because AI is sometimes very dangerous. Yeah, many has many risks. So that this project is very useful in the future, even though yeah, we'll make try and error. Okay. Yeah, we'll open opportunity for audience asking about this project next. Well, everyone, this is the end of the presentation session, and the next session is Q and answer session, and I will open the opportunity for all audience who want to ask the speakers by two kinds of options. First, you can raise your hand virtually and ask directly to the speaker to intend to ask, or by typing on the chat box feature. So I can, how to say, speak the questions out loud. Okay. Any question? Oh, if not, maybe I will ask one of the speaker.
There is one raise hand, Bu. Pak Gunawan Tagalung.
Oh, one raise hand. Okay, Pak Gunawan Tagalung, please. You can unmute your microphone and ask directly to the speaker.
Yes, thank you, moderator. Actually, I want to ask to all speakers about the digitalization of the MSME. I think COVID-19 spread actually is a second threat for the MSME, because I think the previous one was when their business touched by the large enterprises or global digital enterprises through penetration of digital access to society or users. MSE, which managed traditionally, cannot compete with those ones. Digitalization of MSE by government was started with focus on empowering them to access market by digital access. So the policy is introducing this digital access as a prerequisite for obtaining incentive for MSE. So mostly MSE required to have the digital access first before get incentive like subsidies, tax reduction, sales and promotion, and etc. And now the second one, the threat is COVID-19. In fact, COVID-19 hurting MSME until now by lowering purchasing power of the people, limitation on their business operation and others. But I think COVID-19 is an opportunity to accelerate transformation of MSE, to enter digital platform or to develop new business model. Since in this COVID-19, all business aspect also transform to digital form. So in the other hand, COVID-19 is a threat, but on the other side, COVID-19 is also opportunity. But the situation brings us to fundamental issue. How could we provide digital access to MSME properly? As we know, in fact, Indonesia still struggle to close digital divide for more than 12,000 villages right now. This will relate it how government responsible to provide digital access right for MSME. As we know, we're already in liberalization for the digital access industry since Uruguay round of WTO. My question is, what is the legal or regulation development approach should be taken on regard this issue? And then the second one is how this digital access right as a justice for MSME from the economic perspective post-pandemic COVID-19. Thank you.
Okay, thank you, Pak Gunawan. So we'll answer the question first. Maybe Pak Gunawan can appoint one of the speaker.
Yeah, maybe Professor Makarim or Professor Juliati. Thank you.
Oh, thank you very much.
Professor Jurianti first.
Okay, thank you, Pak Gunawan, for the question just now. Yeah, I totally agree with your perspective just now, saying that digitalization is actually a must in this post-pandemic area. So as we can see that as pandemic COVID-19 has already slowed down, okay, the business are now becoming more active again, and there's some sort like changes in the performance of the business, whereby businesses more inclined towards having online economy, online transaction, digital. They have digital platform for their business. And in Malaysia, of course, we know the fact that SME is the business that is handled by kelas pertengahan, so that in terms of their skills and knowledge about digitalization is quite low, and in order to overcome that particular challenges, the government has in every part of the states has given the training, has given the opportunity to all people who involve in SME business to enhance their online skills, their digital skills, okay, in order to keep pace with the changing situation right now. So I think, of course, it needs time, okay, in order to see the outcome later on. But we are slowly keeping pace with the challenge now. Okay, thank you. That's my response.
Okay, thank you, Professor. Please, Prof. Edmond.
Yeah, Thank you very much for the question and also for your statement. I agree with you regarding the digital access. But more than that, if the platform or marketplace do not have a guarantee to prefer to domestics, it's such like a policy of a government regarding the broadcasting. We found in the regulation they should have a percentage for the local content. So the priority for the market, internal market, to facilitate the domestic product, it's also needs for the SME. This is it is logic for us to have a potential market in our place, of course. On the other hand, as I mentioned before, there is no guarantee that platform cannot what you call influenced by the shareholders. So the company that had already mentioned before, actually the stakeholders not from domestic, but also from the foreigners. So the foreign investment have a consequences to our marketplace. And then it also depends on to what extent the consistency for the government implementing their policy, because it looks like favorable. It sounds good, like affirmative to the SMEs, but actually in the market condition, the unfair competition is happening. If you found that our younger entrepreneurship, build their own startup company, and they should face the big company like a state-owned company holding the market. They have many subsidiaries. There is many on-state companies that already in market and make a barrier for the new younger generations. It also is not so good. So you can find in the market related to the digital identity, and also for the digital sign, digital signature and certificate, digital certificate. You can find it that state-owned company try to hold the market. And then the other things, the third point, it's not only for embedding or give a training and education to the SMEs, but make the good policy that give opportunity for the new commerce, for the new line of business, rather than it looks like we release the vertical integration or horizontal integration between the digital companies. So I agree, and then I'm adding some complementary points for this point of view. Thank you.
Thank you, Professor.
Thank you.
Thank you, Professor, for the explanation. Hopefully the answer can cover your questions, Pak Gunawan. The next question is coming from the box text. Maybe I will spell it. The question from Alicia Mabel. What is the percentage of success given by the Malaysian government's program concern whether it can help restore? This question for Prof. Suryati.
Right, thank you for the question. I'm proud to say that significantly the economic recovery strategies taken up by the government of Malaysia has significantly contributed to the GDP of Malaysia, whereby it records a record 50% GDP growth in first quarter of 2022. So I think whatever the steps that has been taken by the government has proven that we are slowly towards getting back all our previous transaction into the normal situation before the COVID-19. So this 5% increase in the GDP is actually a good signal, okay, for Malaysian economics to survive again. Right? Thank you.
Thank you. Thank you, Professor, for the explanation. How about Mbak Alicia? I hope that it can answer your question. Next question is coming from Margareta Tias, asking for Prof. Jeko. What is the best way to handle the post-pandemic condition in South Africa, and what is the most significant difference between the rule of law in South Africa compared to Indonesia in this case? Please.
Thank you very much for the question. South Africa currently is what we would call a state that's fighting institutionalized corruption. During the pandemic, certain legal loopholes and stuff was exploited, and massive corruption happened during the pandemic and before the pandemic, especially during the pandemic, where PPE corruption, vaccine corruption, all that stuff took hold. So the big difference between South Africa and Indonesia is law enforcement in Indonesia and the idea of criminal justice in Indonesia is stronger than currently in South Africa. And the best way to handle what we're going through now is to have a functioning justice system, to have a justice system that puts the needs of the victims first, above the needs of the government, above the needs of the people that exploit. So yeah, I hope that answered your question.
Okay. Yeah, thank you very much, Prof. Jeko, for your explanations. It can answer your question, Tias. Well, next question. Any other question from the audience? Okay. Well, if there is no any question, so I want to ask a question for Pak Edmond. Are you still there, Pak?
Yes, I'm still here.
Okay. Actually, I'm very interested with privacy, data privacy. And okay. I want to take my PhD for the topic. And I want to ask you about the data portability in Indonesia. As I, how to say, open the PDP bill in Indonesia, Indonesia has no the concept of data portability, just interoperability. If I compare with the GDPR and PDP bill in data privacy, PDP bill. So, what the challenge, Prof, to implement the portability data in Indonesia? So why PDP bill not cover the portability data?
Discuss about the right to data portability. Give us an understanding that the data itself it's represent about ourselves, so it means it's like a property of us. So it inherit to what you call it's a part of us. And then when I use this to access another system, I give an example. If I make a new application and you would like to log in my applications. You can use login with Yahoo, login with Facebook, login with others. So it categorized as soft identity providers. But the policy in our country now still prefer to have a centralized identity. Even though for some, for another side, the citizen number, it's blatantly not secure for us. So there, I think this is the lower reasonable expectation to privacy, because it represents our birth, our code of territory. So it must be better if the identity ecosystems. So that's why I had already mentioned about we need a clear legal framework regarding the national electronic authentication systems, because based on the single centralized identity system like this, we are not open identity. So the government always put citizen number as a requirement for any access, even though that is a private access. But on the other hand, even though we accommodate, it must be better if we clear this first regarding the federated identity management. It should be there is a trusted identity ecosystem in Indonesia in order to accommodate another identity provider, not only based on credential such citizen card, but we can use another identity provider, soft identity provider such as digital certificate or digital signature providers. You can find Privy ID, and also you can find FIDA and others players around this systems. So I would like also to add in the information, progress information still discussed in have a discussion on a UN Central Model Law on AIDAS. So right to data portability needs a clear legal framework regarding electronic authentication system, particularly for the identity card. So you had already know, I guess, that the latest news is citizen numbers now could be used for the tax number, right? There is a news. KTP NIK dapat digunakan untuk nomor pokok wajib pajak. Yeah. But there is no guarantee if there is company or there is another colleague from others to use your data, to have a confirmation to your data, and the electronic government should give us any information to notice, hey, this is your personal data. Yesterday, someone had already asked about your data. But there is no facilities like that in our nation, government now. Yeah, so that's why you not control to your data. So on the other hand, it looks like the government treat your data as their asset. It's not good for the privacy in basic principles. But the law of citizen, the law now about administrasi kependudukan, the population administration, they give special power to do that. So that's why, in my opinion, the draft of personal data protection is not so smooth in our process, because the government seems not not agree if we have a special commissioner for protecting our personal data. So in short, answering, the right to data portability depends too much on the clear policy, to what extent we implement or accommodate federated identity management or open identity. Yeah, thank you. I hope that it's clear answer.
Yes, it is clear answer. Prof. Thank you very much. So it is about the framework and the readiness of the system, right? Okay. Any question?
Okay, can I have question?
Yeah, please.
Okay. I will ask for Professor Lu, yeah. Hello, Professor Lu. Yeah. In regard in implementation of artificial intelligence system in Hong Kong, yeah. How the government facilitating the small medium enterprise to adopt this technology? Yeah, because this is the advanced technology. Yeah, I know in China, government facilitate small medium enterprising in farming, in manufacture by facilitating them and providing them IoT services free. Government subsidize all the services. In Hong Kong, how the government facilitating this new technology to the SME? This is for Professor Lu. And then for Professor Pujiono, if Professor Pujiono still with us, it's just like you have explained to us that there is a correlation between the strategy in achievement of SDGs to development of SME. My question to Professor Pujiono is what is the best approach in reconstruction of the regulation in SME sectors to maximize our efforts to achieve the SDGs target? Thank you.
Okay, so I will answer first quickly. Yeah, so your question is the how in Hong Kong the government promotes or facilitates the AI kind of infrastructures. Actually, you are right asking the right question exactly, because in the mainland China and in Hong Kong, actually it's on the one country, two system. In the mainland, actually the AI-based governance, government surveillance, and then those things are kind of more like a top-down, okay? So this is like the China is trying to striving for the AI forefront, the high ground. And then they are using all kinds of policies, subsidies, and then other things, try to facilitate the digital transformation. Actually, in Hong Kong, actually, on the other hand, it is more like a bottom-up approach. Of course, the government has its own called smart city blueprint, which highlights the key sectors, especially Hong Kong is dominant for the financial sector, okay? So the fintech related digital transformation, medical tech, edu tech. So and then these are the more advanced areas. So they are moving faster. So however, Hong Kong does not have its large manufacturing base. But no matter what, so we think that a smart city needs a solid ethics base. So this ethics base is drawn upon the protection of private rights, or it's more like a top-down AI-based governance system. So that is why you can see in my PPT, our task 2 is to first conduct a survey, okay, a large, wide range survey on the value differences, what people think are the most pressing AI ethics challenges, their adoption of AI in their respective industry. Already there are some reports, but we are doing a more comprehensive one. Yeah, yes, I hope that answers some of your queries. Thank you.
Okay. My time. Okay. Thank you, Pak Dakalim. The existing condition, yeah, many our regulation that less participation is the first condition. I mean that like this condition, criminal 2 or 3 step ahead than our regulation. In other hand, I can say that our regulation 2 or 3 step behind with the criminal acts. So this is the problem, the real problem. And at the time, we know the real condition like pinjol, pinjol, and the other small business in financing that make our citizen maybe afraid with this condition. So what should we take reconstruction or regulation in hand that we should make regulation that relate with micro, small, and medium enterprise. The first thing that regulation should more anticipate with the economic dynamization, like you said previously about the digitalization. This should more anticipate. And the second, our regulation should give more protection, especially to consumer, because in small, medium business, many consumer that dirugikan with the small, medium enterprise. This is the problem. This is the problem. And the third regulation and policies, government policies should give stimulus with the business, like I said before, relevation in tax, terus there is the different treatment in credit, bank credit. This should government take in their regulation or in their policies. And the third, the government should know the difference between micro, small, and medium enterprise with the conventional business. I mean the higher ones, higher one business. So the government should give different treatment. The micro, small, medium business should be given more stimulus, more treatment, more good treatment than conventional business. This is the ways that if the government should reconstruction their regulation more adaptive with dynamization of micro, small, and medium business enterprise. Thank you.
Professor, do we need implement asymmetric regulation between the large company and the micro and small medium enterprise?
Yeah, I think we should have asymmetric regulation.
Thank you, Professor.
Yeah, Gunawan, thank you.
Thank you very much, Professor, for the answer. I think this is the end of the session because the time is up. And let me tell you about the summary of this seminar. The COVID-19 pandemic still significantly influenced various aspects of human life today in 20 countries. For example, in Malaysia, Prof. Zuriati have already explained in regards to the impact of COVID-19 to many sectors in Malaysia, such as education, economic. Therefore, Malaysia government has implemented the law regulation and program that needed as a form of innovations in the post-pandemic world, especially for the economic sector such as Prihatin. Yeah. It's also in line with the explanation from Prof. Jeko that has already explained regarding the ideal type of law in the pandemic era. The legal paradigm must be adaptable and universal. Furthermore, from Professor Edmond, we also learned about the critical legal issues of digital economy regarding accountability and trustworthiness of the system. And the Prof. Husrianti also explained about the comparing proper framework of SMEs law in various countries. Prof. Puji also explained us about the challenge and opportunity during the pandemic based on the law and instrumental of government policy. And the last but not least, probably you explains about his big project that hopefully it will be run better and give us benefit for the future. Okay, thank you very much for the attention. I would like to express my gratitude to all the speakers that already explain and give the insightful knowledge. All the committee, hope all the best for you. The speaker also, today's material can be useful in the future. Thank you, and that's all for me. Wassalamualaikum warahmatullahi wabarakatuh. I give back to the MC.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Miss Umi Khairahpati. And now, before we leave this room today, please take a moment to take a picture. For the committee, please be ready to take the picture. For everyone, please on the camera. Okay, 1, 2, 3. Okay, now for the second screen. One, 2, 3. Okay, and the third screen. Wait a moment. 1, 2, 3. Cheers. Okay, thank you very much.
Thank you, Prof. Puji,
Okay.
Prof.
And that
Makarim,
brings us
Prof.
to the end.
Suryati,
Thank you so much for your time and attention. I would like to apologize if there is a mistake. I hope all of you have a very nice Saturday. And hopefully this international webinar bring us a lot of benefit and experience. See you in another international webinar hosted by Faculty of Law Universitas 11 Maret. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you, Profesor Ayo, Profesor Pujiono,
Thank
Profesor
you
Jati,
all.
Suryati, Prof.
and then Bu Kone, Krisyanti, Prof. Nawan. Thank you, bye.
Bye-bye.
Thank you, moderator.